Well, if you or your loved ones or someone you know is in the Cuban, Haitian, Nicaraguan, or Venezuelan population, then you woke up today to a big surprise because the United States Supreme Court just sided with Donald Trump to deport 500,000 people that are here legally under temporary protective status to allow them to work here, to live here with a sponsor while they seek asylum and other permanent legal status. No, says Trump, all of you Cubans, Haitians, Nicaraguans, and Venezuelans, not by case, but en masse, you're leaving. You're leaving your friends and family behind, and you're going back to war-torn countries that you just left. And the reason you were given temporary protective status by the Biden administration and other administrations in the first place. I'm Michael Popak. Let's dive into the new United States Supreme Court decision. It appears to be a 7-2 decision, but with a stinging rebuke and dissent written by Ketanji Brown Jackson. This case came out of Massachusetts up to the First Circuit, which refused to grant a stay. But now the Supreme Court, at least apparently on its face, has granted a stay, meaning Donald Trump is free to deport people, 500,000 people, while the appeal continues, because they have determined that Donald Trump and the administration are likely to win on this mass deportation and violation of our temporary protective status program. You're on MeidasTouch and Legal AF. I'm Michael Popak. Let's get to it. First Circuit did the right thing. The trial judge in Massachusetts did the right thing, finding that Kristi Noem and the Trump administration acted arbitrarily and capriciously in making not a case-by-case determination, but doing it en masse. There's even an argument that under the statute that the new Homeland Security Secretary cannot undo that which the prior Homeland Security Director already determined. In other words, those countries didn't get any better. The rationale for keeping these people out of harm's way and under our protective wing hasn't changed just because there's been a new election. I mean, that's the argument. And so, but the Supreme Court, in its infinite wisdom, and I use that term lightly, took a look at the factors, and there are factors that have to be applied. Factors that Ketanji Brown Jackson quite pointedly says and calls out in her dissent, I'll read to you from in a minute, says they botched the assessment. Now, we call them in the business the Niken factors or the Niken factors, Nken. It's based on a case from 2009. And before the Supreme Court can grant a stay while an appeal is pending, because the merits haven't yet been decided, that the court has to determine whether, and it's supposed to be a heavy burden, especially when the lower court, the First Circuit, has already denied the stay. But the Supreme Court has to determine that there is a fair prospect that the decision was wrong by the First Circuit. So in other words, a reversal on the merits is likely, that cert is likely to be granted, and that the irreparable harm lies with the Trump administration. To which Ketanji Brown Jackson asks, what is the irreparable harm to the government? The government's being burdened because it can't go forward immediately with its depraved, unconstitutional deportation program? How are they being injured? Versus if you're looking at the balance here, look how these individuals now uprooted from families, from sponsors, from a life they've been living for more than 2 years in the United States. They are not undocumented. They are documented. We sometimes refer to them, because that's how the statute refers to them, as parolees, but don't be confused and conflated with the language of prisons. They're not on parole. It just means they've gone through a process. They're under the jurisdiction of our immigration process and an immigration law judge, and they've been let out back into society for the next couple of years while they do a couple of important things. Stay out of trouble, work to live the American dream, and try to apply for permanent status in the United States. I mean, if they can't get asylum, and they can't get from the United States, and they can't get other legal status to stay in the United States, yes, they will go. They will not be able to stay under the TPS. But this is not about people violating the temporary protective status that have stayed too long. This is just people who are currently within their 2-year window who are being shown the door. And for those in the Cuban community, the Venezuelan community, which is very strong where I live in Miami, shame on you. If you thought that Donald Trump was going to avoid your communities, your constituencies, because you celebrated him and helped get him elected, you were wrong. I'm sure you know 1 degree of separation, if not closer, people who are now being forced to leave this country because they did nothing wrong. Let me read to you from Ketanji Brown Jackson's scathing dissent here, because this is what we do, and it's important. Give me 1 second here. Let me pull it up from my magic bag of downloaded Supreme Court decisions. Here's what Justice Jackson said, because the actual order on this emergency application is 1 paragraph. So here's what she said. She went through the factors under that case, Niken that I told you about. And she said, in that assessment of those factors, on page 2, the court has plainly botched this assessment today. It requires nothing, next to nothing from the government with respect to irreparable harm. And it undervalues the devastating consequences of allowing the government to precipitously upend the lives and livelihoods of nearly 500,000 non-citizens while their legal claims are pending. Even if the government is likely to win on the merits in our legal system, success takes time, and the stay standards require more than anticipated victory. She goes on to say nearly 500,000 Cuban, Haitian, Nicaraguan, and Venezuelan non-citizens are in the United States after fleeing their home countries by virtue of temporary permission granted to them by the Department of Homeland Security. And that's why we call them parolees. She goes on page 3 of her 8-page dissent, joined by Judge Sotomayor. The decision whether to stay a lower court's order does not reflect a back-of-the-napkin assessment of which party has the better legal argument. Because she's challenging and calling out the majority for their sort of back-of-the-hand, gratuitous assessment when human lives are at stake. She goes over the fact that the government has failed in its burden, that the harm is greater to the individuals, and that ultimately these human beings deserve more from our country and from the United States of America. That's how this works. What's going to happen next? Well, it's obvious. The Supreme Court has now given the green light to Donald Trump to deport 500,000 people from these groups. The people that sponsored them, I'm sure, are devastated. The people in those communities, I'm sure, are devastated. These are things that should not be forgotten at the midterm election. I hope that they're not going to be. We don't have the luxury of the silent majority any longer in this country. We need to act out. We need to put things in plain terms for people to understand it in the marketplace of ideas. And we've got to move forward towards the midterms with these things in mind. If you're a part of those communities or you love or supported those communities, this is a wake-up call for you. It should be a wake-up call for you. You don't have the Supreme Court to protect you. On immigration, they're about 50-50 in siding with Donald Trump. But on important issues like this, they're siding with Donald Trump. And they're violating their oath, and they're violating the statutes that were created by Congress to protect just this type of group from the war-torn and politically and economically unstable places from which they came to seek a better life. Whatever happened to Emma Lazarus's poem etched at the bottom of the Statue of Liberty? Give me your poor, you're hungry, you're tired. Sorry, let me try it again. I don't mean to botch it. Give me your poor, you're hungry, you're tired, your huddled masses yearning to breathe free. That is what my grandparents and great-grandparents, that's what they saw if they got that close when they came through the Ellis Island Naturalization Center. And that's what most people think of is proper for America. And we got to keep continuing this fight. We'll fight together here on the MeidasTouch Network. We'll fight together on Legal AF, the YouTube channel. Hit the subscribe button in both places. Help us continue to bring this programming to you uninterrupted. Till my next report, I'm Michael Popak. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.